Hello everybody, welcome back to the English Law channel. So I'm carrying on talking about contract law, particularly some of the difficulties reconciling common law with European Union law. So I talked about how the European Directive on Unfair Terms and Consumer Contracts is obviously part of UK law, and continental and English law courts have dealt differently with statutory interpretation. A tricky thing comes in the 1994 regulations. So the European Directive was drafted and it's translated into various languages, and the English version it talks about goods and services and it doesn't mention land. Whereas if you look in the French edition, for example, it says vendeur de biens, so the seller of goods, but in French bien, which we often translate goods, can include land, whereas in English it doesn't. There was a case which touched on this, London Borough of Newham against Khatoon in 2004. So the Court of Appeal has decided to sidestep the differing interpretations because of the Consumer Rights Act. Anyway, so we talk about contracts which are selling land. So there are various principles which are applicable across contract law, and which apply to all different kinds of contract. Now, there are some particular areas where some of the general principles are disapplied, and there are rules which are especially for a certain area of contract law. So contract law is somewhat fragmented. Remember, there's a distinction between business-to-business contracts and business-to-consumer contracts. So we've often contractualized the relationship between citizens and the state since Dame, oh God, what's her name? I forget. The woman who's in charge of Westminster in the early 90s, Westminster City Council. Shirley something or other, it's not Shirley Williams, said we have to treat the ordinary voters and so on like customers and try to provide a good level of service to them. The heir to the Tesco fortune, that's the one I'm talking about. Anyway, so in the real world, well, we have lots of contract law rules, and we see the way people behave, and that people have studied the way that contractors actually behave, and people are more willing to bend the rules and to be reasonable, they might think, rather than rigidly adhering to what it actually says in the contract. Anyway, so if somebody breaches a contract slightly, people usually don't overreact. So contracts are supposed to be about consensus ad idem, so people agreeing to things. Obviously, until the 20th century, it was largely a laissez-faire approach, freedom of contract theory. So you can make any contract you want, even you can agree to a very unfair contract, very disadvantageous to oneself. But in the 20th century, we've displaced that presumption. Often we're asking, what would a reasonable person do or say in this situation? Anyway, but as they say, the law is an ass. The law is foolish sometimes. This is why equity comes in, as it's often said, to mitigate the harshness of law. So we've had courts of equity since the Middle Ages, and various equitable doctrines have been introduced into contract law: promissory estoppel, undue influence, a specific performance, and things like that. Well, that's a remedy, specific performance. So there are primary remedies, such as you have to paying damages, and that's not often law courts, and that's somebody's right. A specific performance out in courts of equity, but the Judicature Acts in the 1870s amalgamated the two types of courts. But remember, equitable remedies are at the discretion of the court, so they don't actually have to order them. But remember the old equitable maxim: he who comes to equity must come with clean hands. He mustn't be a sharpster himself, much less have done anything illegal. And equity delights in equality. What else does equity do? Yes, you must not sleep on your rights. You must take prompt action if you wish to avail yourself of any equitable remedies. So since October 2000, the Human Rights Act was domesticated into United Kingdom law and had legal effect. Their convention rights, as in they're found in the European Convention of Human Rights, and among these are the right to life, protection of property, the prohibition of torture, inhuman, degrading and treatment, the outlawing of slavery and so forth. You have right to respect for your family life, your privacy of your correspondence, got freedom of thought, conscience and expression and so forth, freedom of association and assembly, the right to wed and to form a family, and we've outlawed discrimination where that's unfair. There are times when discrimination is held to be fair. So anyway, some laws have horizontal effect. So the Human Rights Act, Section 6.1 said it's unlawful for a public authority to act in a way which is incompatible with the convention right. So public bodies of county councils, any emanation of the state, so they mustn't treat individuals badly like that. So the Human Rights Act has touched upon the law of contract because the Human Rights Act has a horizontal effect. So it impacts relationships between individuals, the state, or between the state and companies, and so on. So the House of Lords said the right to respect for private and family life needs legislation. Because what about rented property, and does this apply to same-sex couples as well as straight couples? Well, it does now. So it's a controversial question, the horizontal effect of the Human Rights Act. So no doubt it's going to develop further. Okay, there was a Department of Energy and Climate Change, DEC, against Breyer Group, public limited company. So this is an area where the Human Rights Act protection of convention rights has affected a contract. So in this case, the government department had a subsidy scheme in order to promote a small-scale generation of renewable energy. But anyway, there's more take-up than was foreseen, therefore it was more cost. So the Department of Energy and Climate Change broke with its earlier promises and tried to save £1.6 billion by lowering the subsidy payable for the electricity produced from renewables. So companies said that they'd suffered £195 million worth of losses because of this. So anyway, the Court of Appeal said that implementing these changes had unfairly and unwarrantedly deprived the company of their rights and the protection which was guaranteed to them under Section 1 of the First Protocol of the European Convention on Human Rights. So the companies should have got damages. So anyway, contract law is found, of common law style, is found in all these common law countries. So there are codes in Roman law countries, as in Francophone, Hispanophone countries, Lusophone countries, as in La Code Napoleon in 1804. Or Germany's got Bürgerliches Gesetzbuch, as in the civil law book, really. So this is one source, the only source for legal principles, you might think, but that's not quite true. So it can't possibly have provisions for every single eventuality that arises. But anyway, so all sorts of interpretations have to be made. Even Napoleon himself said, "Mon code est perdu," my code is lost. As I pointed out, that Scotland's a Roman law and a common law system blended together. There's a sort of mélange in Cyprus and now in the Republic of Ireland. Okay, there are Lando's principles of European contract law, which you ought to look into if you want to get deeper into this. Another important piece of legislation to look for is the regulation on common European sales law, and the European Commission published this. So trade within the European Union is worth over €2 trillion per annum, and so that's why contracts really matter, because we just do so much commerce with each other. And the idea is so that this will reduce costs. But that doesn't mean that contract law is identical in every member state. So there are 27 member states now. So the World Bank did a study called Doing Business, looking at just how easily you can do business in 190 countries, almost every independent country. So common law countries are only 20% of countries in the world, but they're 5 of the top 8 for the simplicity of doing business: New Zealand, Singapore, Hong Kong, USA, and the United Kingdom. So the main Roman law jurisdictions in Europe are rather lower. France at Germany, France at 32, Germany at 24. Okay, so non-codified systems, as in Roman law systems, make things simpler and faster. Anyway, so there's uniform customs and practice for documentary credits, or the uniform customs for short, as we call it, which tells you how to do a lot of this international trade. There's an international chamber of commerce which tries to regulate this. There's the United Nations Convention on Contracts for the International Sale of Goods. sometimes it's called the Vienna Convention, or the CISG, signed at Vienna. It's not the Vienna Convention on Diplomacy. Because if goods are produced in China and transported by a Filipino crude ship registered in Liberia to Canada, which is then going to transit to the USA, and oh my God, and who owns this company? Whose law applies? Anyway, the CISG is to sort all that out. Okay, so that's just a little bit about some of the challenges of reconciling different types of contract law. Okay, toodaloo.